I hope you enjoy the presentations. The first one is going to be on pure economic loss in tort and some recent statements from our courts on when that can be claimed. And that will be done by Ian Peck and Alana Brogan from our firm. Thank you.
Thank you for the introduction, Frank. Good morning. We are pleased to be here today to talk with you about recovery for pure economic loss and why it remains a narrow right of recovery in Canada. We're going to begin with a primer on what it is and what the courts have traditionally done with these types of claims. This will be followed by a discussion on a recent decision from the Supreme Court of Canada that is touted as clarifying the framework that we are to use when we're analyzing claims for pure economic loss. You will then see whether this is the case when we take you through a number of decisions that have been decided since that guidance provided by the Supreme Court. So in basic terms, pure economic loss is a financial loss that is not connected to physical or mental injury to a person or to physical damage to property. I'll give you a few examples. Let's say a manufacturer negligently manufactures a smoke alarm, and you have that smoke alarm in your home. If you decide to seek the cost of removing and replacing that smoke alarm, then you will be claiming something akin to a pure economic loss. You are looking for financial loss, but you are not seeking a loss because of any damage to your own property or to your person. Another example from the case law, an Ontario cattle farmer sued a feed manufacturer for financial losses after contaminated feed caused an Alberta cow to develop mad cow disease. Well, this had a devastating effect on the Canadian cattle market because the international borders to Canadian trade for cattle was then closed down. In that case, again, the Ontario farmer did not have a direct loss to his own property or to himself, but he certainly suffered financial losses. I think it's fair to say that we are most familiar in negligence with claims for consequential economic loss. That is, a direct connection to a physical injury to a person or property. For example, a person gets injured in a motor vehicle accident and they can no longer work and sustain a loss of income. Or a machine breaks down due to a manufacturing defect and is no longer in operation. There's loss of use of that machine and also a loss of use of the equipment. You can see the direct connection there to a physical injury. I'm going to turn it over to Ian now, who's going to take a look at what the courts have traditionally done with these claims for pure economic loss.
Good morning. So there's three classic cases which have really been the defining cases on pure economic loss up until the clarifications in Maple Leaf. The first one is the negligent performance of a service or the negligent misrepresentation. The classic case is the Livent matter where Deloitte & Touche, who was the auditor of Livent, had not caught certain fraud by the owners of the company and certain officers of the company and allowed the company to continue to operate in poor financial circumstances, eventually leading to its downfall when the fraud was discovered. And what the receiver was allowed to do was step into the shoes of the company, kind of like in insurance subrogation, and pursue the auditor to try to recover some of the losses. And basically what the court had said is, look, you were negligent in signing the audit statements, which is a misrepresentation, and you were negligent in the way that you performed your duties and didn't uncover the fraud. And so some of the lost profits were allowed to be recovered. Another case which is very near and dear to both mine and Alana's heart is a construction case called Winnipeg Condo and Bird. In that case, a part of the cladding of an existing condominium fell off. And of course, what happens a lot when buildings are developed is the developer several years later no longer exists. And so the condominium had no right or ability to recover against the non-existent developer. So what did they do? Well, they brought a claim of negligence against the builders and the engineers. And in that case, the Supreme Court of Canada allowed a recovery because there was a real and substantial danger to the occupants of the building and the owners. And so in that very narrow exception, they were allowed to recover the pure economic loss. In that case, the pure economic loss was an investigation that they undertook to investigate the cladding of the building to make sure it was going to be safe. Nothing further had fallen off. The economic loss was simply the investigation of the parts that hadn't suffered damage. And then the last case, which goes back quite a long way, is a very interesting case called Canadian National Railway and Norsk Pacific. That's a case where a barge was being towed along a river, and the person driving the barge hit a bridge. The bridge was not owned by the railway, but the railway used the bridge to ship their trains. The railway was allowed to recover damages, and the damages they recovered were the simple, pure economic loss of having to reroute trains all around different other railroad tracks, which cost them more because it took longer to get their trains from point A to point B because they couldn't use the bridge. But the point is, it's not their bridge. And so that's what made it unique, in that the railway had not suffered any property damage. It was the simple extra time of routing its trains. So now back to you, Atlanta.
Okay, I'll now turn to a 2020 Maple Leaf Foods decision of the Supreme Court of Canada. A quick point of interest here, both the appeal to the Ontario Court of Appeal and the Supreme Court of Canada was successfully argued by my colleague Liz Boker. Awesome job, Liz. So I suspect that many of you may actually be familiar with the background facts of this case, as it was repeated in the news cycle at the time. In 2008, Maple Leaf Foods recalled some of its deli meats as a result of a listeria outbreak in one of its manufacturing plants. The news at the time identified Mr. Sub as one of those places where you may have come into contact with the contaminated meat. So as a result of the recall and the negative publicity, the Mr. Sub franchisees, so the store operators, claimed that they sustained both financial losses and reputational harm. What is interesting is that there is no evidence that any of the Mr. Sub customers actually got sick because of contaminated meat, or that any of the ready-to-eat meats that Mr. Sub sold contained listeria. Regardless, what resulted was a lawsuit, a class action claim in negligence in the context of a franchisee relationship, so again, the Mr. Sub store operator against the supplier, Maple Leaf Foods. There was no direct contract between Maple Leaf Foods and the Mr. Sub franchisees in this case. Mr. Sub, the national organization, had an exclusive supplier agreement with Maple Leaf Foods to produce meat to the stores. And there were franchise agreements between the Mr. Sub national organization and the Mr. Sub franchisees that required those stores to exclusively buy the Maple Leaf Foods from distributors. So the issue for the Supreme Court to decide was whether Maple Leaf Foods owed a duty of care to the Mr. Sub franchisees in negligence for pure economic loss. Before I move on to what the court decided, I'll quickly comment on what happened in the courts below. At first instance, Maple Leaf unsuccessfully brought a summary judgment motion to dismiss the claim in negligence for pure economic loss. The motion judge found that Maple Leaf owed a duty of care and negligence to the store owners to provide a product that was fit for human consumption. So they found that the economic losses that were being alleged were reasonably foreseeable, and therefore they could advance the claim. Maple Leaf appealed to the Court of Appeal, and the Court of Appeal allowed that appeal. Instead of finding a duty to the store operators, the Court of Appeal found that the duty of care was actually owed to Mr. Sub's customers, the ultimate consumers of the products, to get a meat that was free from contamination and fit for human consumption. The court quipped that Mr. Sub could not bootstrap its claim onto a duty that was ultimately owed to the customers. So this takes us to the Supreme Court of Canada and more of Liz's star power. The Supreme Court took the opportunity to revisit and clarify the framework that we are to use in analyzing claims for pure economic loss in negligence. The key takeaway from this case, and I'll pull the cat right out of the bag here, is that a critical aspect of any analysis in pure economic loss is the relationship of proximity. You have to look at the relationship between the parties. So the correct starting point for determining whether pure economic loss is recoverable is whether a duty of care exists. And this is regardless of whether you're able to fit your claim for pure economic loss into one of the existing categories that Ian just told you about. To determine a duty of care, you must have both a relationship of proximity And you also have to have reasonable foreseeability of harm. Now, what I found when I was reviewing the cases and preparing for today was many parties seem to focus on that reasonable foreseeability of harm. I'm not sure whether it's because it seems easier to establish, or sometimes it's confused with proximity, but we know because of the Maple Leaf Foods case that you also have to have, well, more than the Maple Leaf Foods case, but we know that to establish a duty of care, you need both proximity and reasonable foreseeability of harm. So the court discussed a two-factor test to be performed in cases of negligent misrepresentation or performance of a service. You need to establish an express or implied undertaking that is by the defendant, so some responsibility that's undertaken by the defendant in favor of the plaintiff, and there has to be reliance on the plaintiff. Those are the two factors. The court found that in looking at those two factors, it's very important to whom the undertaking is given. It has to be given by the defendant to the plaintiff, and has to be in favor of the plaintiff. And also, the reliance must be by the plaintiff. It can't be substitute reliance by others, even if that reliance by others is what ultimately causes the alleged damages to the plaintiff. So in this case, you had to find that Maple Leaf Foods had undertaken some duty to the Mr. Sub store franchisees. The proximity analysis is a little bit different in the category of negligent supply of shoddy goods and structures. In that category, the plaintiff must show that the pure economic loss is connected to a real and substantial danger to a person or property. So that's similar wording that we just heard from Ian in the Winnipeg condo case. So in the result, applying that proximity framework, the majority in a 5-4 decision found that Maple Leaf was not liable in negligence for the alleged pure economic losses of the Mr. Sub franchisees. The court was unable to find a proximate relationship between the two parties, and therefore there was no duty of care owed by Maple Leaf to the store operators. Maple Leaf had advanced its claim in two of the existing categories. In the first, under the category of negligent misrepresentation or performance of a service, the court looked at the two-factor test and found that the undertaking there was actually given from Maple Leaf Foods to the Mr. Sub customers to ensure that the meat was safe. So they found along the same lines as the Ontario Court of Appeal. That duty of care did not extend to the store operators. There was no undertaking by Maple Leaf Foods and no reliance by the Mr. Sub franchisees. In the category of negligent supply of goods, the franchisee's claim did not relate to the cost of averting any real or substantial danger. In fact, the court found quite the opposite, that Maple Leaf Foods had voluntarily recalled its meat and they bore the cost of that recall. So a few takeaways from this case. A narrow right of recovery continues in Canada for claims of pure economic loss and negligence. Implicit in the decision is a reminder that negligence law in Canada serves to protect bodily integrity and property interests, not commercial interests. Pure economic loss and negligence will only be recoverable when you establish a sufficient relationship of proximity. The contractual matrix was very important in this case. The court was heavily influenced by principles of freedom of contract and the freedom to allocate risk among contracting parties. The court specifically stated that it is going to be slow to impose a duty of care on parties that could have bargained for those contractual protections. Before I move on, I think it's worthwhile to note the dissent. It was a 4-judge dissent. The dissenting judges would have allowed the Mr. Sub store operators to recover their losses for pure economic loss. They looked at the contractual arrangements a little bit differently than the majority to find that proximate relationship. They found that the core purpose of the series of contracts was actually to provide the stores with the Maple Leaf food to sell. Further, in looking at the franchise agreements, the court noted a power imbalance that is inherent in franchise agreements. They didn't go so far as to talk about it being a standard form contract, but something akin to that. And therefore, the franchisees, those store operators, had little practical ability to bargain for any protections. So in those circumstances, the dissenting judges would have found a novel duty of care. Okay, we're moving from one sandwich artist to another here. My personal favorite, Subway. The Subway case is a 2021 decision of the Ontario Court of Appeal arising out of a lawsuit by Subway against CBC and Trent University. The case involves a burning question for many of us. Is Subway's chicken real chicken? According to Trent University, not so much. It's about 50% chicken and 50% soy filler. So the action itself arose out of a February 2017 episode of Marketplace. CBC had retained Trent University to test samples of various fast food chicken sandwiches. The Marketplace episode then featured an investigative report about the composition of those chicken sandwiches sold by Subway and some of its competitors. It was reported that Subway's chicken sandwiches were composed of only slightly more than 50% chicken. Well, Subway didn't like this very much. In response, they stated that that was false, the testing was false, that they had suffered financial losses, and that the reporting had unfairly damaged its reputation. Subway estimated that CBC's story reached over 3 billion people. Now, clearly, this was not the viewing of the original Marketplace episode, but the reporting was repeated in other news media, such as the New York Post, USA Today, and where I personally think it reached the broadest audience by Perez Hilton. Subway relied on expert evidence to establish that it had lost damages of over $50 million in the United States and a further $1.5 million in Canada. So what did they do? They brought a $210 million lawsuit against CBC for defamation and against Trent University in both defamation and negligence. Subway alleged that Trent University carelessly performed its laboratory testing and then carelessly communicated those faulty results, causing them pure economic loss. Trent University, in turn, brought a motion to dismiss the action, arguing that the lawsuit amounted to strategic litigation against public protection, so an anti-SLAPP lawsuit. So while the claim is framed in negligence for pure economic loss, this decision is in the context of an anti-SLAPP analysis. At the first instance, Trent's motion was dismissed. The motion judge didn't really get into any analysis of the pure economic loss component of the claim. So Trent University appealed to the Ontario Court of Appeal. Interestingly, Subway did not frame its claim for pure economic loss in any of the existing established categories. So the court accepted that a claim could fall outside of those categories, but you still need to give effect to the Maple Leaf Foods framework. So in this decision, it relies very heavily on the principles that were clarified and discussed in Maple Leaf Foods. So what does that mean for us? There's a focus on proximity. The Ontario Court of Appeal on Subway was unable to establish that duty of care between Subway and Trent University. The court noted that the case had similar attributes to a claim of negligent misrepresentation or performance of a service, so they decided to look at the two-factor test. But when they did so, they realized the factors were totally missing from this case. There was no undertaking of responsibility by Trent University in favor of Subway that Subway relied upon. In fact, it was quite the opposite, or not the opposite, it was a different undertaking. The undertaking was from Trent University to CBC to perform the laboratory testing, and CBC relied on those results to report on the Marketplace episode. This is a really good example of the substitute reliance that that was referred to by the judges in Maple Leaf Foods case. The CBC and its customers relied on the results by Trent University, and that reliance led to the alleged damages of Subway. But that connection isn't enough to establish a proximate relationship. So the court didn't find the relationship between Subway and Trent, and also didn't find anything to found a novel duty of care. The negligence action was dismissed. It's notable that the action is still ongoing. Subway still has its actions in defamation against both CBC and Subway. So 2 takeaways with this case. One is to not mask your defamation claim as a negligence claim for pure economic loss. And secondly, don't mask your soy as chicken in your sandwiches. Ian, I'll turn it over to you to go through a few more cases released in 2021.
Thanks, Elena. So the first case that we're going to go to is a fairly recent Court of Appeal decision called Charlesford Developments in the City of Ottawa. This is a land development case where the city was going through the zoning process with the developer. And what had happened is the developer had purchased the property in issue from the vendor, and the vendor had actually started the zoning process. The sale was conditional on Ottawa actually approving the zoning. So from the standpoint of the buyer, who later becomes the plaintiff, the zoning approval is a critical piece of the puzzle. And what the rezoning was to allow a high-rise condominium to be built. The issue that the case is about is an easement in favor of the City of Ottawa. And during the zoning approval process, the city staff on several occasions referred to the easement as holding a trunk sewer, which is on a neighboring property. And what in fact was in the easement was a trunk water main. So what's the difference? They're both a big giant pipe. Well, the difference is the water main is under pressure and it has millions of gallons of water flowing through it. And so if you need to access that pipe, you need to be really careful about how you do it, unlike a sewer, because the sewer is not under pressure and does not have the same type of flow. The knock-on effect of that to the developer was the city, eventually when they realized this after the zoning approval, said you cannot build your underground parking garage right up to the property limit. And they refused to relax the easement. It seems pretty clear that at some point during the zoning approval, the city realized that they had made a mistake. But there was so much back and forth between the developer, who later becomes the plaintiff, and the city staff, that everything sort of became a mind meld. And it seems pretty clear that the staff never actually and formally corrected their mistake to the developer. So the developer was very upset that he could not build the size of parking garage he wanted because he couldn't sell as many parking spots with the condominiums. Not only that, the developer incurred costs to redesign the project to shrink the parking garage. So the structural engineer had to redo the drawings, and then they had to modify what was going to be let for tender. And so there was direct costs for that. The plaintiffs sued the city, and they won at trial, and they alleged a misrepresentation that had caused them both out-of-pocket costs for redoing the design, but also pure economic losses because they had to carry the project for 2 more years while this issue got sorted out, and also because they weren't allowed to sell as many parking spots as they would have liked to, and they were alleging a pure economic loss for that. So this case was actually argued before the Maple Leaf decision was rendered, and the Court of Appeal had the benefit of the Maple Leaf decision when they rendered their decision. And what the Court of Appeal said was, well, the misrepresentation was in fact in a service performed by the City of Ottawa. They said, you need to look at what the relationship of the parties is and what the city is doing. And so they applied the proximity test. Basically what the court said is, listen, the city has to, as a matter of fulfilling its obligations as a municipality, review zoning. And they're performing a function that they perform for everybody. There's nothing special about the developer in this case, and the zoning is simply one of the very first links in a long chain of events that ultimately will lead to the project. So while it was annoying to the developer to have his conditional sale go through because the zoning was approved, it really was not a situation where there was a relationship of proximity. The municipality was just simply doing its job, and it's allowed to make a mistake in doing it. It's not the type of case where there's an undertaking given that the plaintiff is entitled to rely on that would give rise to the relationship of proximity. And so the next case I wanted to talk about is called Eisenberg in the City of Toronto. And this is a 2021 decision relating to a proposed class action by taxi drivers against the city over the allowance of Uber, the ride-sharing app. And the basic fact situation here is that for many years, the City of Toronto had a very strict taxi licensing bylaw. And to get a taxi license was a fairly onerous process, but once you got it, you had it for life. And it's interesting because the taxi drivers specifically tried to plead different interactions with the city staff when you're going through the licensing process. And some of the things they talked about is that apparently city staff at Toronto, when they give the taxi license, make a representation along the lines of, oh, look, you've got yourself a pension now because you've got a taxi license. They don't expire. So the case was dismissed along the same lines as the case we just looked at, which is, look at, the city has an obligation to enforce its bylaws, and they're allowed to make decisions about changing bylaws. So there's no special relationship between the city by granting a taxi license and then allowing Uber to come in and operate under separate circumstances. That's just the reality of life, and there's no duty of care owed and no relationship of proximity. The next case I want to talk about is a class action, and this involves Capital One Bank as well as some other defendants, including Amazon, which was Capital's web services provider. And this is the type of claim that we're getting more and more concerned of and more scared of, which is a hacking and a data breach claim. And basically what happened is the bank's data was stolen by a hacker, and Capital One has hundreds of millions of clients in the United States, and they had 6 million in Canada. So someone started a class action in Canada on behalf of the 6 million Capital One customers. It's important to realize that no one had actually had their identity stolen. All there was a risk at some point in the future that your identity might be stolen, and then you would incur some costs to recover your identity. And so the statement of claim was struck on the grounds that, look, you're not really in a relationship where there is a real and substantial danger. What you have is the heightened risk that at some point in the future you may suffer a loss. And the court said that is just not the type of relationship of proximity that is going to give rise to a claim, and they dismissed the action in negligence and did not allow certification on that point. And then the last case I'm going to talk about is called Carter and Ford Motor Company of Canada. That's a case where there's a defective product installed in Ford vehicles. Apparently, water pumps in certain Ford vehicles are not going to last as long as they should, and they may break. So what do you have to do? Well, you're going to, at some point, be replacing your water pump with another exact same type of water pump. The class action plaintiffs were divided into 3 subclasses, which is something that's relatively unique to class actions because you need to show a class of people is going to be harmed. And so there was 3 types of classes proposed. One was people who had actually experienced a water pump failure and were hurt because of it, so the personal injury class. Another class is the class that had had their water pump break and damage their car, so you have a property damage class. And then the last is people who had had no failure, but at some point were going to be faced with the annoyance of going to the dealership or a mechanic and having the water pump subbed out because it was defective. And so what the court said was, look, Class C is a pure economic loss class. It is the type of class where you're perhaps going to suffer a loss, but you may not. And so there is no real and substantial danger, and you're not in the type of relationship of proximity that normally gives rise to the ability to recover in tort. So we are pretty much right at time. I think that's what that dinging was for. So Frank, I know, has been monitoring if there are any questions. Alana and I are happy to answer them. And if not, we can move to the next presentation.
Ian, yeah, there is one question that was asked. The viewer has said that the cases you've discussed about pure economic loss are all tort liability cases. Does the concept of pure economic loss come into play at all when looking at coverage under a CGL?
Yeah, so coverage under a CGL may or may not trigger indemnity or even a defense for economic loss, pure economic loss, depending on the type of claim which is made. In a case where there is property damage or bodily injury, those are the 2 things you need to look at when you're triggering a CGL. The CGL is obviously different than other types of policies. A D&O policy has a very, very broad type of coverage, and professional liability policies have a different type of coverage that's not necessarily triggered by bodily injury or property damage. So I think that in most cases, if you have a CGL that you're looking at and you're comparing it to the statement of claim to see, is it possibly covered and do I owe a duty of defense to my insured, what you're probably going to have to look at is, like, is there property damage or bodily injury alleged? And if there's not, you're going to have to take a hard look at whether you do have a duty to defend.